Morning, Kevin. It's good afternoon already. I think you're on mute. Ah. Nice to meet you. I'm Charlie Calari. Good. Sure. Appreciate that very much. And joining me is my senior account manager, John Ryan. Yep.
How you doing, Kevin? Pleasure to meet you. Very good. Thank you.
Thank you.
Hey, Kev, how are you? Good. Glad to hear it. Thank you.
Kev, can you hear me?
Yes.
All right, thank you.
It's on mute. It's not on mute. Good afternoon, Kevin. Kevin. Hello? Hello? Hey, Kevin, it's Carrie. Can you hear me? Thank you very much, sir. Thank you.
Yeah, I'm here. Okay, thanks.
traffic.
Okay.
Her wedding. This is like because we were like she had a wedding yesterday. Her first
Oh.
wedding. Which is why we were like, all right, well this is why we wanted to close it May 1st because we were both off. Everything was fine.
So you're gonna drive with her, right?
I think so. Yeah.
Good.
Depending on where they are.
What do you mean? Then, Harry, do you want to go park your truck?
Not really. I'm leaving a little bit.
Well, I thought you were going with her.
What? I'm gonna drive.
Oh, sorry.
This is what you for me is.
You have everything. You have your checkbook. You have
Wow.
everything. Okay.
Relax.
I'm excited for it.
Okay, yeah, but you're agitating me like you don't usually.
Woo, woo, woo. Right? Right?
Oh, I can't wait because these.
I would invite all legislators into the chambers so that we may begin. Let's start the meeting off, as we always do, with the Pledge of Allegiance, and I ask Legislator Deborah Muley to lead us in the pledge.
Hand over your heart. Please say with me, I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, indivisible, with liberty and justice for all.
All right, Mike, could you please call the roll?
Yes, thank you. Deputy Presiding Officer Howard Copel. Alternate Deputy Presiding Officer Denise Ford.
Here.
Thank you.
Thank you.
Legislator Sila Bino. Legislator Carrier Solage.
Here.
Legislator Deborah Muley.
Here.
Legislator C. William Gaylord III.
Present.
Thank you. Legislator Vincent Muscarella.
Here.
Legislator Ellen Birnbaum. Legislator Delia DeRiggi Whitten. Legislator James Kennedy. Legislator Thomas McKevitt. Legislator Laura Schaefer.
Here.
Thank you. Legislator John Ferretti. Legislator Arnold Drucker. Legislator Rosemarie Walker. Legislator Joshua Lafazan.
Here.
Legislator Stephen Rhodes. Minority Leader Kavan Abrahams.
Here.
Thank you. Presiding Officer Richard Nicolello.
Here.
We have a quorum, sir.
Okay, thank you. We have 3 items on the emergency agenda, and I ask the clerk to call all 3 and the emergencies.
Yes, sir.
You can hold off for a moment. I have several slips for public comment. 3 of them relate to one of the items on the agenda, which we'll call in a few minutes, but one is just a general public comment, so I'll call that now. Richard Clolery.
Can you hear me? Very good. To the members of the legislature, hello again. It's been such a long time since we last saw one another, and I'm here once again to plead my case for increased funding for the buses. Only now there's increased reasoning for this. As you may be aware, due to the pandemic and the recent cyber attack on a gas pipeline, there's been an increase in gas prices, may continue, which will, of course, decrease public using their cars this summer for anything outside of work, which means less recreational driving, which will lead in its own way to less money coming into the Nassau County's coffers. Also, due to the pandemic, there's been shortages of processing chips, which makes it impossible for me to get the latest video game systems, and for everyone else who might want to get a new car or used car, also impossible due to increased prices to such a level that it's too expensive without a loan, who they, if miss a single payment, means that this person with this loan will probably default on it. Don't believe me? Ask your local repo man. Look, I know that you've probably heard this all before, but I want you to think about this. With increased funding, that means more buses for people who can't drive and increased connectivity to railroad stations, to recreational places like Adventureland, like the Nassau Coliseum, to places where they shop. All I'm saying is this. Don't look upon a well-run bus system as a cost, but as a potential benefit for the people of Nassau County, who, because of what is going on, can't drive to the place where they need to be or have to be, or want to be. Also, for the members of the local Republican Party who might want to oppose what I am saying, I want to ask you something. How are you feeling about the National Party as a whole, especially with the opposition to the January 6th Commission, creation creation of voter suppression laws for minorities all over the country. There are attempts to overturn Roe v. Wade, which won't stop women from getting abortions if overturned, by the way. There's support from right-wing extremist news organizations like Fox News. Yes, F-A-U-X News. There are antics like Marjorie Greene's equating the Holocaust to mask wearing. If I were a conscientious Republican, I would be asking myself this. Should I still be one? Especially with what's going on lately. Or should I listen to my conscience and do one of two things? One, join the Democratic Party. Or two, either start a new political party that will require me to be more inclusive of people, or joining an independent party with the same philosophy like the Workers' Party or Independent Party. And by the way, for those of you who may drive and may be afraid of what I'm saying, I have nothing but great respect and admiration for those who drive carefully. Keep up the good work. Thank you for your time, everyone.
Okay, all right. So let's go to the emergencies.
Thank you, Mr. Chairman. Emergency Resolution number 3-2021, an emergency resolution declaring an emergency for immediate action upon a resolution requesting the legislature of the State of New York to enact and the governor to approve an act to amend the retirement and Social Security law in relation to disability, retirement benefits for sheriffs, deputy sheriffs, undersheriffs, and corrections officers in Nassau County. The following ones are Emergency Resolution number 4, 20-21, an emergency resolution declaring an emergency for immediate action upon a resolution requesting the legislature of the State of New York to enact and the governor to approve an act to amend the retirement and Social Security law in relation to providing death benefits for corrections officers employed by Nassau County. The next emergency is number 5, 2021, emergency resolution number 5, 2021, an emergency resolution declaring an emergency for immediate action upon a resolution requesting the legislature of the State of New York to enact and the governor to approve an act to amend the retirement and Social Security law in relation to accidental disability retirement for deputy sheriffs.
Okay, thank you. We need a motion to establish the emergency, moved by Legislator McKevitt, seconded by Legislator Birnbaum. Any debate or discussion? All in favor signify by saying aye. Aye. Those opposed? Aye. The emergency is established. So now I'm going to call the items. 178, 2021, a resolution requesting the legislature of the State of New York to enact and the governor to approve an act to amend the retirement and Social Security law in relation to disability retirement benefits for sheriffs, deputy sheriffs, undersheriffs, and corrections officers in Nassau County. Item 179, a resolution requesting the legislature of the State of New York to enact and the governor to approve an act to amend the retirement and Social Security law in relation to providing death benefits for corrections officers employed by Nassau County. Item 182, 2021, a resolution requesting the legislature of the State of New York to enact and the governor to approve an act to amend the retirement and Social Security law in relation to accidental disability retirement for deputy sheriffs. I think the titles really provide most of the information that's necessary. I don't know if anyone is here from the administration who wants to speak with these, but these are joint initiatives and a part of the legislature and the administration. I would just say that the last one, 182, 2021, provides an accidental disability benefits for deputy sheriffs to be increased from 2/3 to 3/4 final average salary, which is in line with other similar positions, whether it be the police department, et cetera. So, any debate or discussion on these three items? Okay. Let's say Reggie Whitten.
I just want to say we were discussing. I think this is the third time that we've tried this in my tenure, and we do support it, and we hope that it gets the signatures that it requires going forward.
We echo that completely. Any further debate or discussion? Right. Hearing none, all in favor signify by saying aye. Aye. Those opposed? Carries unanimously. Now we move on to the regular agenda. The first three items relating to the capital plan are not being called today. We go to item 4, which is a hearing on a proposed local law to amend Article 10 of the Nassau County Administrative Code to require written notification to towns, villages, cities, and school districts of agreements proposed to be entered into by Nassau County for the operation of multi-unit shelters to be located within such jurisdictions. That item is moved by Legislator Walker and seconded by Legislator Schaefer. It is now before us. This action we're taking with respect to this local law is in response to the administration's actions with respect to the proposed emergency shelter to be located at 120 Jericho Turnpike, and actions that they took before the public and before legislators and most people knew what was happening. So what the purpose of this is to provide greater transparency. It is a focused piece of legislation, narrowly focused on the issue of providing notice when such issues are being considered, so that at least 10 days prior to the execution of a contract or agreement for shelter facilities in Nassau, the Department of Social Services must provide written notice to the legislator representing the district where the shelter is to be located, as well as town, villages, cities, and school districts where the proposed shelter is to be located. So again, this is rather than providing notice after a contract has been entered into, this legislation simply says before you enter into a contract for a shelter, you'll provide all of the interested parties, especially the elected officials and office holders of the proposed action, to enforce greater transparency and allow the public additional information before you're entering into the transaction for this. So, any debate or discussion on this proposed law? Mr. Legislator Drucker.
Thank you very much, Presiding Officer. I just want to reiterate some of the comments I made a couple weeks ago when this bill was before the committees. I support this bill. I really do. But I also recall I really strongly supported the Jericho Family Support Center. But I was extremely disappointed as this bill addresses the manner in which the community and the elected officials like ourselves, myself, who represent the community, were informed of this contract and this plan at the very last minute. Actually, after the school district knew, after the community knew, at school board meetings. So I understand the need for it because the transparency is critical. But I also I'm hopeful that this bill will not minimize or marginalize this county's obligation to legally, we have a legal and moral obligation to house homeless men and women and children of Nassau County. It's a statutory obligation as well as a moral obligation. And many of these people are, seniors who have spent long, productive lives contributing to our communities, or veterans even, who have made extraordinary sacrifices for our nation. I had filed an amended version of this clerk item that would ensure the notification of local officials regarding the placement of shelters, but respect the legal mandates of confidentiality and will not contain identifying information of residents of the proposed shelter, nor disclose the address of any shelter housing domestic violence or abuse victims. One of the most unfortunate elements about the debate about the Jericho Family Support Center was the level of dishonest vitriol that had been directed towards the concept and who the people were that would be residing there. And I really feel that our shared sense of humanity and decency make it imperative that we as a united community reject some of these toxic attitudes of a few who, out of ignorance, racial or class prejudice, fear, or just callous opportunism, seek to obstruct these efforts. So I just would like to make sure that going forward we can operate under the guise of this bill in a manner so as not to impede our ability to deliver life-saving services or further jeopardize the safety or welfare of our most vulnerable population. And I urge the administration to consider the amendment that I had filed too. So thank you very much, Presiding Officer.
Thank you, Legislator Drucker. And I would say that this bill was very narrowly drafted, and it just focuses on providing that notice before the contract is entered. And in no way does it, or could we ever, minimalize or marginalize our legal or moral obligations. And in no way, obviously, does it require disclosure of any confidential information or identifying information, because, again, that would be in violation of legal mandates. It's, again, simply requires that before the county executive enters into a contract for such a facility, she provides the officials with notice. And I think I know you stated it many times you're in support of that. Legislator Walker, then Legislator Bino, and then Legislator Dewey.
Thank you, Presiding Officer. I agree with what has been said already this morning, and I really do believe that if this had gone in the right direction and we did know ahead of time and we sat down with all the parties involved, I would hope that that shelter would have been there. And we do need to do something different. I mean, we have families that are, living in hotels with nothing for the children to do there. I mean, one bedroom where, you have 2 beds and 4, a mom and 3 children are there. No other services are there for them, and a facility like this, it was my understanding, would have certainly helped and would have offered so much more to our families that have to live in a shelter right now. And with training, perhaps for the adults and child care right there for the children, after school, tutoring and so on and so forth. And again, if things had been done properly and it wasn't at the last minute and no one knew about it and there wasn't so much confrontation regarding it, I would have hoped that would have been operating. So I hope this, by passing this, it stops that problem in the future, and that we move on and we find very, very productive shelters for those families that need it the most, and at a time when their lives are, really dealing with a lot of struggles. And so, like I said, I hope that it's supported by everyone, and that we do move on and do things and be upfront about them right from the beginning. So thank you.
Okay. Thank you, Legislator Walker. Legislator Bino.
Thank you, Presiding Officer. I'm not sure who I should pose this question to. Would it be Legislator Walker? Were you the lead sponsor on the bill?
I guess any one of us could potentially respond.
So I'd like the definition for multi-unit. I'd like to understand what that would that capture. Because currently what we have proliferating certain communities are units, are shelters that house 4 to 5 families in one house. Is that considered multi-unit?
We're going to try to get you an answer to that question. It's potentially a term that's defined in state law, but let's, why don't we leave this hearing open? Other legislators obviously can have their say at this point. We'll get you an answer to that question before we conclude. And if necessary, we'll go on to the next item, then come back.
I appreciate that.
Sure. Anyone else like to speak on this? All right, so we'll leave that hearing. Oh, I'm sorry.
Yes, hi, this is Legislator Szilagyi. Good afternoon.
Sure, good afternoon.
Thank you, Presiding Officer. I would like to know what internal mechanisms the county has to ensure that this piece of legislation meant for notification is not meant for other purposes, such as pretextual purposes to keep certain people out of certain neighborhoods? Thank you.
I mean, there's nothing that could be read into the text of this local law that could be used to imply that. It's very simple and straightforward, and simply requires notice of the shelters, notice be provided to elected officials in the community in general when a contract is entered into to place one of these shelters in a community. And obviously, the only purpose here, the only purpose that could be legitimately read into this is that under those circumstances, when they're about to enter a contract, the community, the elected officials at least, should know about it. So I don't think it can be used. There's certainly nothing in the statute, in the language of this statute, could support what you're suggesting.
I'm not suggesting that, presiding officer. It is a simple reality that these laws are used in this fashion. Thank you.
I categorically reject that. This law could not be used in that connection.
I hope that we are not devoid of reality here. That is exactly the way these laws are being used.
Well, I mean, the alternative is that you don't want to let the community have notice of the placement of a shelter in the community. So is it supposed to be kept a secret? I mean, that's the alternative to what all we're suggesting is, all we're requiring is that 10 days before a contract is entered, you tell the community you're about to enter a contract. That's simple enough.
And at that point, that information can be used to encourage fear-mongering, to scare people from allowing these people who are in need to get the need that they help.
But also, on the contrary, it could be used to provide information to the community about the need for such a site, or the circumstances of where it's being placed, and it actually might build support for something before it goes forward. I fully believe that transparency is the better way to approach this.
At Georgetown and Boston College Law School, I have researched various laws during the Reconstruction of the South, in which Jim Crow laws were used to muster up a lot of hate and anger to make sure certain people were not allowed in certain neighborhoods. Do we know if this law will be used in that fashion?
You know, look, I'm not even going to respond to that. If you're going to start raising Jim Crow in response to this legislation, then there's no reasonable argument that can be made. Or there's no reasonable discussion that can be had. Legislator Walker?
I just want to look back on our hearing that we had regarding this issue and social services. And the attorney for social services actually sat here with the commissioner and said that if he had been at the meeting with the commissioner, he would have advised her not even to let the school district be aware of the fact that they were discussing the shelter. You know, we were in the throes of COVID at that time, where every single parent, and you know, Legislator Szilagyi, I know you are aware of this, that every single parent had to decide if their child was going to school in the district, if they were going to do remote learning, if they were, you know, if the school had offered a hybrid, what they were doing. The whole busing issue was your child, if they were eligible for a bus, were they going to be on the bus, or were you going to drive them to school? I mean, it was an even crazier time than we normally have. And this hotel is not in my district, but I am the chair of Health and Social Services, and there were so many questions regarding the hotel, you know, at that time. There was a pool that was in the hotel that had like garbage in it. You know, they emptied the pool and they threw garbage in it. I asked, did we even see the site? Do we know what it's like? I mean, I want to assure the health and safety of the residents. These are our families that are going into these shelters, and we have to make sure they're a place where we should have our families. And like I said, I totally agree with the concept of what the shelter was going to offer, but I just think it was done, you know, very quickly without any knowledge. And I mean, there were certainly a lot of questions I wanted to ask, and I wanted to know. And every time whether we had a hearing or whatever, a discussion about it, I said, this is not in opposition to the shelter. This is just regarding the way this was done dealing with this hotel. So in no way would I look at this as being a way to keep residents out of, any of our residents out of any community. So I can only share my information about it.
Any other legislators?
Good afternoon, Presiding Officer and legislators. I'm concerned with regard to this legislation and hearing that you all have concerns about how this was put forth even heightens my concerns, because coming from situations where I have seen the plethora of these types of shelters, both legal and illegal, in communities of color with no jurisdictional resources, no supports, nothing until something happens, there's a fire or some kind of incident where children's lives are in jeopardy or families. I have myself moved a veteran's family out of a similar type facility, as Legislator Walker stated, that was unsafe for the veteran who was in that shelter, and this hotel was located on Northern Boulevard. So the fact that the North Shore gets those very few circumstances, but the South Shore is inundated with them. So the concerns for these underserved communities, including communities of color and veteran communities, ties into finding out where will the public get to speak with regard to how they want their communities to be represented. Even when we had unescorted children who were summarily just dumped in our county, the village of Hempstead received an increased number versus even Baldwin, where I live. There were hundreds that were put into the village of Hempstead and maybe 14 that ended up in Baldwin. And I don't think any crossed the threshold in Garden City or any place north of Northern Boulevard. So the disproportionate number of these shelters, however they're administered, however they are monitored or established, still creates a problem that, yes, rings true to the same types of systemic and systematic racism that was engendered upon people of color through Jim Crow and other type laws, many of which are still indirectly on the books, even in our illustrious state of New York. So I'm very concerned about how, one, this legislation was put forth to begin with, and the fact that there isn't as much input locally with residents who are not able to attend these hearings, because I myself literally have left a medical office where I've been assisting a critical care physician since COVID started to attend this full meeting, because I'm continuously concerned about what is happening with my tax dollars when I have to travel along roadways and I read in the paper about certain residents who are going to get checks, but then we have a medical facility that's going to get shut down that people are using as a political jockeying position that they claim they may be putting in some type of veteran village. But I find it very interesting that all these ideas for homelessness and housing and veteran services come right before an election. But to this issue right here, where we're talking about multi-unit shelters, I too concur with Legislator Bino as to what constitutes multi-unit. What are we talking about in terms of the family? What are we talking about in terms of the support services that are going to go into these hotels? We have many empty facilities. You have a structure that's being built right over here where Sears was. I'm pretty sure it looks like it's going to be yet another medical type of facility. But we need to address the shortage of housing and resources for all of our residents, but particularly those who are the most vulnerable, the most underserved, and that includes our veterans, that includes our seniors, and that includes young people who can't afford to live here. They don't want to stay here. But if we do have families that are in crisis, that are in need, that need to be in a multi-unit facility or a shelter or some type of supportive housing, they should receive the same care, consideration, dignity, and sense of decency in a place to live. And guess what? It should be distributed across the board, across the county, across the borders and boundaries that are set up to keep it in significant numbers in the South Shore, but everything on the North Shore has to be a certain way, and we're all paying the same amount of taxes, but we're not getting the same resources. So I am hoping that it goes beyond this hearing, that we can individually, in all of your respective legislative districts, you talk to your community residents and get an idea of how many of these shelters are in their own communities that they know about. Whether they know about them or not, it still is going to be an impact on their taxes and their breakdown. So the concerns are there, and we cannot continue to just rush things through, throw it on the wall, and see what sticks, and think that the taxpayers are continuing to put up with that. Thank you.
Any other public comment on this? All right. I'm being told that the term multi-unit is solely in the title to this legislation, and the text of it actually refers simply to shelter facilities. So what we are going to do today is we're going to close the hearing, and I will not call the local law. I think we're going to need to make sure that the terminology being employed in the legislation is as focused as possible. Because it's clear what we want to do, but we want to make sure that the legislation is narrowly focused on those types of facilities, such as the one in Jericho, where you were placing a shelter that could accommodate 80 families. So it's, so again, we want to make sure that the language of the legislation is as clear as possible. So, anyone else have any comments or discussion during this hearing?
Presiding officer?
Yes.
If you will, I would like if our council was kept in a loop of what was happening before it shows back up on an agenda.
Yeah, yes, absolutely.
Because I have some thoughts about.
We would welcome those thoughts. We'll welcome the input of Mr. Pines.
Thank you.
Okay. So we need a motion to close the hearing, moved by Legislator Kennedy, seconded by Legislator Coppell. All in favor of closing the hearing signify by saying aye. Aye. Those opposed, the hearing is closed. We are going to jump to item 8, since there are people here, several individuals, community leaders who've come to speak on this item. So we're going to do that first. This is a local law to prohibit the smoking or vaping of cannabis in all county-owned properties. We had a hearing several weeks ago on this, and what we're going to do at this point is we're going to amend the statute to decrease the penalty for violation from $200 to a maximum amount not to exceed $25. Why we are doing that is because the state legislation sets a penalty with respect to the use of cannabis products of $6 to $25, and the county's legislation cannot be inconsistent with that amount. So, I need a motion to amend by Legislator Ferretti, seconded by Legislator Schaefer. All in favor of amending this legislation to reduce the amount of the penalty from $200 to $25 signify by saying aye. Aye.
Aye.
Those opposed? Okay, the amendment passes unanimously. Is there any further debate or discussion on this legislation, or anyone who wants to speak on its behalf? Okay, Deputy Presiding Officer Coppell? I'm sorry, we had public people here to speak on this. I'm sorry. Yeah, let's bring up the 3 speakers. First off, we have Elizabeth Boylan.
I want to thank you for passing the ordinance. I'm disappointed in the penalty, but the fact you have the vision to post all these signs on Nassau County properties, over 6,000 acres of parks, beaches, golf courses, beautiful preserves, which my family, friends, and guests, we take advantage of, and I know that many people living in Nassau County and the surrounding area take advantage of. So I hope that this will reduce or eliminate people smoking anything on the Nassau County-owned properties, and especially the way the secondhand smoke affects our most vulnerable, our children and our elderly. We just, stopped wearing masks because we're vaccinated with the pandemic, but we still have an epidemic, which will be only fueled by the use and the legalization of marijuana. So thank you. I also encourage you, if you could get to your colleagues in the town of Hempstead, town of North Hempstead, town of Oyster Bay, and encourage them to opt out. The pot bars, the pot sales, that will be problematic for the towns. And I know people say, well, they can go to the next city. Well, you know what? Go to the next city. Let's make it difficult. We have a beautiful county. We don't want to be New York City. That smell is not only horrendous, it's also dangerous to people who have compromised systems. So thank you. I hope to see that those signs are posted at all the facilities that you have, because that's clear. And you are supposed to be as strict or more strict than the Clean Indoor Air Act. So thank you for your vision for protecting Nassau County and keeping it beautiful for all our families, friends, and surrounding neighbors. Thank you.
Okay, next we have Susan Blauner, who's from Saving Lives and Found Five Towns Coalition.
Good afternoon. I'm here as well to echo Liz and to echo Ruth Ann here, who will be stepping up in just a moment. We are grateful, we are thankful for the local law to prohibit the smoking or vaping of cannabis. As you know, we're here to protect the youth and the families of our community. We work long and hard hours to do that, and we're greatly appreciative of all that you do at the legislature here. Thank you very much.
Thank you very much. Ruth Ann McCormick, Rockville Center Coalition for Youth.
Good afternoon. Thank you for passing the ordinance to protect our communities and the health of our youth. I just wanted to go over some data that we have from our Rockville Center youth from our 2019 youth survey results. Rockville Center youth display some of the highest rates of underage drinking and marijuana use, where adolescence has become the stepping stones for future addiction and life-threatening behaviors. When comparing Rockville Center core measures to county, state, and national data, past 30-day use of marijuana and alcohol often exceeds Nassau County and the state. Future survey rates of use and RVC's parent youth focus groups further confirm why underage drinking and marijuana use are prevalent in our community. Older siblings and friends purchase beer for school-age children, and parents would rather have kids drink in their house. Parents are also talking about providing marijuana to their youth now that it's been legal, and partaking in marijuana use as a family. This is very disturbing to us and to our school officials and to our medical professionals. I would hope that Nassau County steps up their education, prevention, and just basic messaging of the dangers that marijuana use can do to the teenage brain. It also drops the IQ points as much as 8 points for heavy marijuana use. And also it affects our youth and their mental health by increasing suicide and psychosis in our youth. And as far as the revenue fund for the state, only 20% will be left for drug treatment and public health education. We're hoping our schools will enforce prevention education with our youth if they are found with marijuana in school. We're also hoping that our social host laws will be adjusted to include marijuana. You know, when a person 21 or older in the county and the state provides marijuana to a youth underage, there are stiff penalties for this. We have our own social host law in Rockville Center, and they are adjusting that in our village, and we thank our mayor and our town board for that. So I just want to hope that the county steps up their education about the dangers of marijuana use to further protect the future of our youth that are already suffering so with suicides, mental health issues, and peer pressure. Thank you.
Thank you very much. Deputy Presiding Officer Coppell.
Ruth Ann, all of you actually, all three of you, thank you so much for what you do. The Rockville Center Coalition has been a leader for as long as I've been involved for the protection of youth. This legislation is focused on protecting our young people. Older people, we're going to do what we want to do. And we can't do much about that at this point, but we certainly can set examples for our young people and show them that at least where we're in charge, we're not going to allow this to be going on. And the efforts that you all put in, the tireless work that you put in for so long, and not only on marijuana, but on drugs in general, on tobacco, and just in general, to protect the young people who are, after all, our future, is wonderful and admirable. And once again, just thank you. And I hope that, and I expect that pretty much everyone here is going to go along with this legislation. We only wish that we can do more.
Thank you, and I appreciate everything you do, Howard, and our support, the support you provide to us. My colleague at Long Beach Aware, Judy Vining, also thanks you for this and is hoping that further education will come out county level for our youth. Thank you.
We will look to doing further education on the county-wide level, but I did attend a program last year from CASA, the Community Against Substance Abuse in Manhasset. The program was given by Dr. Jeffrey Reynolds from the Family and Children's Association. It was truly an extraordinary and eye-opening program. So to the extent that if you haven't had him in as a speaker yet, you may want to think about doing so. He certainly knows.
We are strong colleagues with him, and
Okay.
he does support us, so we welcome his expertise and education.
Okay, great.
He really is the best.
Thank you. Sure.
I just want to say we're also members of the Nassau County Heroin Prevention Task Force, which is chaired by Renee Fechter under the auspices of Madeline Singas. And it's an incredible task force. There's over 500 people on that list. The individuals that are involved, the professionals, social workers, law enforcement, people, former addicts, recovery, they're a phenomenal group of people. They worked very hard. We're all very disappointed about this legislation, but we're pursuing prevention and education, and there's all sorts of events happening to educate our public, especially with the heroin and the fentanyl. The marijuana, with the polysubstance use, it's becoming a big problem, but that is an incredible group that I would ask that each legislature, if you can, take time out once a month to attend one of those meetings and listen to the members on that task force and their subcommittees. It's an incredible, amazing source of support and recovery and help, and I encourage you to do that. Thank you.
Thank you. Legislator Ferretti.
Thank you, Presiding Officer. Thank you, ladies, for coming out and for your words. And I'm going to, of course, support this legislation, but I just wanted to put a comment on the record. The fact that this fine has to be reduced and amended, this bill has to be amended to be reduced to a $25 fine, is a travesty. I mean, Ruth Ann, I believe you spoke about the messaging we need to have to our children. I agree 100% with you. But what kind of message does it send that this body's hands are tied and we can only fine somebody $25 for violating this? You could have two people standing next to each other in a park, a county park, one smoking a cigarette, one smoking marijuana. Both are not permitted. And the one smoking the cigarette's going to get a ticket for $200, and the one smoking pot's going to get a ticket for $25. What message does that send to our children? The fact that our hands have been tied by Albany on this is a travesty. It's the wrong message to children. And as the Deputy Presiding Officer said, as long as we have anything to say about it, we're certainly going to do everything we can to protect the community from this. But the people up in Albany really need to get on the right page on this. Thank you.
Legislator Walker.
I agree with Legislator Ferretti, and I want to thank you, ladies, for all you do to protect our young people. And I really can't thank you enough. And it's truly my hope that once September starts and things are in a bit more of the normal than we've had for the past year and a half, Our police department does a great job with educating our youth, our school children. They get into the schools, they do various programs. They've tried to keep up with them as much as they possibly could, during COVID, but that's been an issue. And, we've seen those results. We've seen the opioid addiction rise again, and various problems that we've had that we were really attacking full strength ahead, and it hurt us. It hurt us. COVID hurt us in many ways that, I think people don't even realize. But again, I'm sure that hopefully they will get back in the school buildings, and the more we can educate our young people, the better. And again, I thank you for everything that you do.
Any other legislators? Okay, hearing none, I'm going to call for a vote on this item. All in favor signify by saying aye. Those opposed?
Aye.
Carries unanimously. Okay. Well, I am going to go, I should have done this before. Okay. I should have done this at the outset, but I'm going to go to the consent calendar and call those items now so that those members of the administration who are here waiting to hear these, we can take care of this right now. These are all items that went through committees a couple of weeks ago. They've been agreed upon by the majority and minority that they can pass without any further debate or discussion among the legislature. So here we go. Item 13, Ordinance 45. Item 15, Ordinance 47. Item 16, Ordinance 48. Item 17, Ordinance 49. Item 18, Resolution 73. 19, Resolution 74. Item 20, Resolution 75. 22, Resolution 77. 23, Resolution 78. 24, Resolution 79. 25, Resolution 80. 26, Resolution 81. 27, Resolution 82. 29, Resolution 84. 30, Resolution 85. 31, Resolution 86. 32, Resolution 87. 33, Resolution 88, 34, Resolution 89, and that's it. Moved by Legislator DeReggie Whitten, seconded by Legislator Kennedy. Any debate or discussion? Hearing none, all in favor signify by saying aye.
Aye.
Those opposed, carries unanimously. They carry unanimously. Okay, then we go back to item 5, which is a hearing on a proposed local law further postponing the date of the 2021 sale of tax liens pursuant to Article 2 of Title B of Chapter 5 of the Nassau County Administrative Code. Moved by Legislator Muley, seconded by Legislator McKevitt. I don't know if there's anyone here on behalf of the administration on this item. By the way, that motion was to open the hearing. I should have a vote on that. All in favor of opening the hearing signify by saying aye.
Aye.
Those opposed, hearing's open. Katie, do we have a speaker on this item?
The treasurer is on his way over. He was just waiting for the consent calendar to be called.
Oh, okay. When you say he's on his way over, he's coming from which building? Is it 240?
He's coming from 1 West.
Oh, he was, okay. There he is.
Okay, just want to catch my breath for a minute.
Okay, yeah.
I'm sorry. I was listening in and I just didn't get a chance to. Okay, good afternoon, legislators. Beaumont Jefferson County Treasurer. The item before you is a postponement of our annual tax lien sale. And in light of the continuing economic difficulties caused by COVID-19, the New York State Legislature recently adopted Chapter 104 of 2021, which further postponed or delayed the tax lien sales for COVID-19 hardship declarations from May 1st to August 31st of 2021. So the item before you is to further postpone our county sale for a date to be determined by the Treasurer's Office beyond August 31st of 2021. So after August 31st of 2021, we're proposing that we will set a date for the annual lien sale.
Okay, all right, thank you.
Sorry about that.
No, thank you very much. Any debate or discussion?
I have a question. This is Laura Schaefer.
Oh, okay. Hi, legislator.
Hi, Mr. Jefferson. I'm just curious, do we have to do that? Like, what's the reason for the process? The state isn't already enacted this. Do we just have to follow and sort of approve it on our own, on the county level?
Yeah, so this is the state, actually, their approval of the 104 of 2021 sets a date that allows taxpayers to file a hardship. So as a result of that, we have to notice taxpayers or delinquent taxpayers, and we cannot sell their lien until after August 31st.
Okay, thank you.
Anyone else? No other legislators? Okay. Oh, sorry. It's hard to see over there. Legislator Ferretti.
Yes, thank you. Just a quick question while you're here, Mr. Jefferson. You weren't here for the vote, but on the consent calendar, we passed the reimbursement for the resident, the 95-year-old resident who had the issue with the assessment, the exemption. So now that that's passed, do you have a time frame as to when she'll be reimbursed?
Yeah, once we get that signed resolution, we'll reimburse her. The resident that in question, we mailed the affidavit and the W-9. We received that. We have it on file, and as soon as we get the signed resolution, we can issue a check.
So it should be pretty instantaneous once you get the signed resolution?
Once we get the signed resolution, yeah.
Okay.
We have everything else in place.
Thank you.
Legislator Walker.
Mr. Jefferson, I'm going to take advantage of the fact that you're also here in front of us today, but can you tell us, we've been told time and time again that the checks, reimbursement checks to veterans and those who had the errors on their, tax bills, that those checks were being sent. We've told our residents over and over that they were being sent. They were being sent in this many days. Have those checks started to go out? Because obviously I'm still getting calls from the residents that they have not received a single check.
Yeah, so in anticipation of that question being asked, I checked just before I left the office. The checks for Oyster Bay went out. North Hempstead, those should be going out this week. And we're working on the Hempstead file, which we have about maybe 500 more properties to review. But Oyster Bay, they do have them in their hands. In fact, today we received a call from a resident who received a check, and we have to reissue it because of a death in the family. But I can say Oyster Bay is definitely, those checks are out the door.
Okay,
North Hempstead is right
and if you
behind it.
received a call that someone got them, if they didn't get them yet, they should be getting them any
If they
day.
haven't gotten a check yet, they should be getting them, and they should call my office, and we can research and we can tell them when it was mailed, and if they don't receive it within a couple of weeks, we can reissue the check. But they're in the mail.
Well, I would hope that they would receive them in a couple
Well,
of days
hopefully in
if they
5
went out.
days, but
Right.
just in case it gets lost in the mail, we usually want to wait.
Okay,
A
but
couple
all of
weeks
Oyster Bays
before
have
we-
been sent out,
Yes.
and now you're working on North Hempstead. Should
North
be out
Hempstead
this
is
week.
already was in the controller's office last week. That they were reviewed. We expect to have a check run on those either today or, no, I'm sorry, Tuesday or Thursday is when we would run
Okay,
check.
and then Hempstead will be next.
And then Hempstead is in the queue.
Okay, thank you.
Okay, you're welcome.
Okay, anyone else? All right, thank you, Beaumont.
Okay, you're welcome. Thank you.
Any, Rita, I was going to say any public comment, but it looks like you're it today.
Meta Maraday, Baldwin resident, and a strong advocate for veterans, and I appreciate Legislator Walker's question because I too have gotten some calls and I'm concerned. I support this legislation as far as the liens being put on hold. I'm still concerned about what actually is being done for any resident that is facing this possible situation of having their home sold from up underneath them. I'm concerned that there are a number of residents, again, on the South Shore, and the fact that Hempstead, again, South Shore, seems to be always the ones bringing up the rear, and usually in most cases we have the most numbers in terms of seeking these exemptions and needing those exemptions, but we also have residents in the South Shore who were impacted from Superstorm Sandy. Many of them were still living in rental facilities. They did not receive any of this rental income that was set up with regard to the COVID assistance. Research has shown the limited amount of money that actually went to rental assistance. Many of those families were impacted. So I'm concerned about what is actually being done as opposed to just a brief delay to address the issues that caused these residents to be in these situations to begin with, including a number of veterans who are possibly within that pool. I myself have sat with veterans, older veterans, again coming across the county, not just the South Shore. I've sat with them at these hearings and these sales. It's also an embarrassment that our veterans who have served our country, that we will proudly walk around and put on a lapel pin, and as soon as you can get back to those parades and the pancake breakfasts, you'll be standing there and saying you're going to do all the things you claim that you're going to do, and they're still living in fear in their homes because they have this type of situation waiting for a judgment to come up. So I'm hoping that there is some type of directive, some type of proactive resource planning in place to do something to help these residents to stay in their homes as opposed to just delaying the inevitable for them to be put out and among the homeless. Because again, if we don't have a proper facility, because we still have not determined where we could actually shelter folks in place, because we just don't have any more room on the South Shore to actually house people if we're not focused on providing home supports and resources. So again, I support this for the most part, but I still have questions as to what is being done for the residents. These are not just statistics. These are taxpayers, these are residents, these are veterans, these are families, mothers, fathers, and children who run the risk of being put out of the home, probably the only home that they've ever known. And I'm just concerned as to what is being done to address those issues. Thank you.
Okay, thank you. Any other members of the public? Any other debate or discussion? Hearing none, we need a motion to close the hearing. Moved by Legislator Walker, seconded by Legislator Reggie Whitten. Somebody's... That's Denise. Seconded by Legislator Reggie Whitten to close the hearing. All in favor of closing the hearing signify by saying aye.
Aye.
Aye. Those opposed? Carries unanimously, and the hearing is closed. We go to item number 10, which is a vote on the proposed local law further postponing the date of the 2021 sale of tax liens pursuant to Article 2 of Title B of Chapter 5 of the Nassau County Administrative Code. Moved by Legislator Reggie Whitten, seconded by Legislator Walker. Any further debate or discussion? All in favor signify by saying aye.
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 Those opposed? Carries unanimously. Now we go back to number 6, a hearing on a proposed local law to impose certain requirements on the Department of Assessment with respect to evidence presented at small claims assessment review hearings. Moved by Legislator Rhodes, seconded by Legislator Ferretti. That's motion to open the hearing and a second to open the hearing. All in favor of opening the hearing signify by saying aye.
Aye.
Aye. Aye. Hearing is now open. This is an effort to create greater transparency and fairness as part of the SCAR process. And these concepts in this local law stem from conversations that we have had with numerous constituents who have participated in these pro se hearings. And in particular, in particular, it's pro se hearings. It's not claimants who are represented by representative law firms, but by individuals who are doing it themselves. There are a number of issues that they're facing at these hearings, one of which is they are being presented with comparative values for the first time by representatives of the county for houses that are supposedly comparable to their own. Having seen these comparables for the first time and no ability to check them, the constituents are unable to provide distinguishing characteristics which we think would help to achieve a fairer, more just outcome to these proceedings. That's just one of the examples. But anyway, what the proposed legislation does, it states that not later than 30 days prior to a hearing, the Department of Assessment must mail a notice setting forth the evidentiary proof that the pro se petitioner may present at such hearing. That is just giving the petitioner an idea of what type of proof, as an individual and someone who's not an attorney for the most part, would like to know as to how to present their case to at the forum. Also, not later than 30 days prior to a hearing, assessment must disclose the evidence it will present to the pro se petitioners. Assessment can only present evidence that is used to determine assessed value in dispute and cannot offer any other evidence to support its determination. Now, I know the administration has submitted a couple of memos, one from Mr. Ray Orlando, Deputy County Executive for Budget and Finance, as well as a memo from the County Attorney's Office. Do we have anyone here from either OMB or the County Attorney's Office?
Connell Denyon, County Attorney's Office.
The gentleman that's in the seat over there?
Robert Miles, Deputy Assessor.
Okay. Mr. Denyon, you weren't the author of the memo from the County Attorney's Office, correct?
No, but I am familiar with it.
Okay. Well, why isn't the county attorney who wrote it here?
The county attorney asked me to appear in his place. He was unable to attend.
So, actually, I meant the deputy county attorney who actually wrote the opinion. Why isn't he here?
Well, I'm sorry, Mr. Cashow.
No, not Mr. Cashow. I mean the deputy county attorney, the individual who actually wrote this thing.
I think you're asking questions about internal processes in the county attorney's office.
It's not an internal process. You didn't write the memo, correct?
I assisted Mr. Cashow, and he directed and oversaw the process of the memo.
So who else worked on it in the county attorney's office?
I don't know if I'm the right person for you to ask those questions. I prefer someone in either the county attorney himself or the chief deputy county attorney to answer.
This is not a purpose. The purpose is not to trick you or to get overly complicated. We simply wanted to know there's somebody in the office, and I think you could probably glean it from the content of the memo that somebody from your office actually wrote it. So I think that's the person we'd prefer to have there. It's actually Mr. Scott. His email address is on the bottom. Is he here?
I believe that's just an error.
Okay. So then you assisted in the process. Who else wrote it with you?
Again, I don't think these are proper questions for me. They're for Mr. Cashow or the chief deputy. And I could ask her to come over. I answer to Mr. Cashow and others in the county attorney's office.
Here's why I'm asking that question. We wanted to have the individual whose opinions are represented in this letter. I understand it. It comes from the chief of the department, but we wanted to speak with the person who formulated these opinions. It's very simple.
Again, I assisted. I took part in this, but Mr. Cashaw is the person who delivered the opinion under his name, as all county attorney opinions are. And I think those are types of questions that are properly directed at him or to the chief deputy.
Okay, all right, then go ahead with what you were going to say.
No, I'm here to answer any questions you have.
You don't want to present the argument that's in this memo that was delivered to us? You simply want to answer questions?
I'd be happy to go through the memo if that's what you prefer.
Well, you want to give us the gist of the memos?
Certainly. The county attorney is of the opinion that the local law is not authorized for a number of reasons. Because without state law authorization, it would improperly relate to the judicial review of taxes and would be inconsistent with state general laws. It would also require county employees to take certain illegal actions or violate a rule of professional conduct. And it would also present the county with additional refund liability and other costs. The judicial review of taxes, the county would be violating provision of the New York Municipal Home Rule Law, which requires that a law such as this not supersede any general or special law of the legislature because it relates to the judicial review of taxes. And the inconsistency with state general laws is Article 7 is a state general law, and this law would prevent judges and hearing officers from obtaining the evidence that is permitted to be presented under Article 7 of the Real Property Tax Law, and whatever is permitted by state law and prohibited by local law is inconsistent. And if it deals with a statute where the state has expressed its intent to control the field, which it has in this case, Article 7 is the exclusive law, the county would not be able to enact this without state law authorization.
What is your concern about the financial impacts?
Well, if with the county, from a legal perspective, if the county is not able to present evidence that it otherwise could, we would lose more cases, there'd be more refunds. It could open us up as well to claims of perhaps waste under the general municipal law or maybe impermissible gifts under the Constitution, because we would, in effect, be allowing people to get refunds without presenting a defense that we could otherwise present.
Shouldn't the focus of the entire process be on a fair outcome and determining what the actual assessed value of a property is?
I couldn't agree with you more, and the state has set up Article 7 to do that as a de novo process, and therefore it's in the hand of a judge or hearing officer at that stage. It's no longer about the assessment. It's now a judicial review of the assessment, which is a different thing, and it's governed by state law. It's not a Article 70. It's not an Article 78 type review of the action of the assessor. It's again, it's a brand new look at what the value is and what the other issues are, based on the grounds that are in the statute, and that's governed by state law.
Let me ask you this: if I'm a resident and I've challenged my assessment and I'm going to SCAR, I'm not an attorney, and then I show up at a SCAR hearing and the county attorney is offering comparable properties values, shouldn't I have the opportunity to look at those properties if they're in my neighborhood, so to point out the distinguishing features? Wouldn't that be fair?
It may be a good idea, it may not be, but it's just governed by state law.
Well, you keep going back to state law, and you keep referring to the state laws with respect to taxes. These hearings don't involve taxes, correct? They involve the assessed values of homes.
Well, they involve the judicial review of assessments, and if found to be improper, result in a refund of taxes.
Well, that's a different thing. I mean, obviously, this law is regulating taxation and taxes, but again, these hearings involve assessment.
I would say that there's no effective difference. I think that the judicial review of assessments and taxes are effectively the same thing in this context.
So every action the county takes with respect to assessment has to be consistent with laws with respect to taxation. Is that what you're telling us?
Judicial review. Laws that would relate to judicial review.
Judicial review of assessment. Well, why is that different than an ARC proceeding on assessment? Why is that?
ARC is also governed by state law.
Right, but specifically the state laws that you've pointed out involve taxation, which is not what this is. This is assessment.
Again, I think that it is effectively the same thing.
So, and what's the basis for your thought?
Again, that because it's a judicial review of assessments, and assessments will lead to a refund in taxes if the court finds that the assessment was improper.
But if ARC determines that the assessment was incorrect and leads to a refund of taxes, it's the same principle. So then doesn't your rationale apply to ARC as well?
ARC is governed by state law that allows the county to.
But you're saying, but there's laws respecting taxation. ARC is bound by laws with respect to taxation?
ARC is bound by its statute, which authorizes it to do that administrative level of review.
But we're going around in a circle. I mean, I'm trying to find out where this inconsistency is, and you keep bringing up laws with respect to taxation, trying to make a connection with a judicial proceeding with respect to assessment.
Well, ARC is not a judicial proceeding. It's an administrative proceeding, and it's governed by
I'm saying that that's what your argument is, but what I'm saying is there's no difference practically between what ARC is doing and what is being done at SCAR.
Well, actually, there are two different things. One is administrative review under its own section of the RPTL, and the other is judicial review under a separate section, separate article.
But they are both dealing with the assessed value of a home, correct?
Yes, to some extent, right. There are other things that go on.
Okay, to some extent. What else are they dealing with other than determining a fair assessed value to a home?
Exemptions, whether the property is misclassified, whether there was a ratio issue, which is an inequality claim. So there are other things that go into it besides what's the value of the home. That's part of the review.
Ratio is involved, correct.
Right, it's part of the review.
But in terms of making laws relating to taxation applicable to these hearings, why is it applicable to a SCAR hearing and not an assessment review committee determination?
Because the state legislature has separately authorized everything that ARC does.
Is that under the taxation laws?
It's under 523B of the RPTL, as authorized to be in our administrative code.
So that's not under the taxation laws?
It is, but it's also authorized by the state legislature, as opposed to this proposed local law would not be authorized by the state legislature.
I think there was a term that Legislator Ferretti used, but I'm not going to use it right now. Anyone else have any questions? Legislator Rhodes?
Thank you for your presentation, Mr. Denyon. Just a couple of follow-up questions. Essentially, it sounds as though the county attorney's point in all of this is that somehow by this legislation we are attempting to change what state law says the process should be for these SCAR hearings. That's essentially what the county attorney's opinion is?
Yes, that's part of it, yes.
Okay. However, when you look at what we've actually are attempting to do in this law, we're simply governing what is disclosed by our own internal county employees. We don't change the process of state law at all. The SCAR hearings still proceed the same way that SCAR hearings would proceed. We're just controlling the information that's provided by our own employees and disclosed to participants in that hearing.
I don't necessarily agree with that, because what the law does is say that if the county fails to provide the information required by the local law, it would be prevented from offering the evidence it otherwise could under the state law, and therefore that is different from the state law. There's nothing in the state law that says that the county would be barred from presenting evidence in a de novo proceeding that the hearing officer or the court would need to determine that assessment for the first time.
But why wouldn't we have the ability, just as any client would of any attorney, why wouldn't we have the ability to control the information that we present at a hearing?
Well, for one thing, the law not only requires that a disclosure of what the county's evidence would be, but also requires what the county attorney has concluded could be legal advice to the other side, which would present issues of.
Well, let's deal with the first issue first. Why don't I have the ability as the client to direct our employees as to what information they may or may not present at a hearing? No, it doesn't. Understand, in this legislation, we're not preventing the court from, or the hearing officer from receiving any information. We're simply making a determination as to the ground rules that our department is going to operate under as to what information is provided.
Well, I do think there is a restriction on the ability of the evidence to be presented to the hearing officer, because the law says it has to be done 30 days prior to the hearing, when the real property tax law requires them to only send a notice out 10 days before. So
All right, so let's say we made the 30 days 7 days. Does that fix the problem?
it would take care of that particular part of it, but again, the failure to...
No, well, conceptually, because we keep bouncing around to different topics here. What I'm trying to understand philosophically is why us giving direction to what county employees are going to do somehow violates state law.
Because it's under state law that you're not allowed to do that local lawmaking because it would interfere with ultimately the evidence that would be presented in the forum where the hearing officer or the judge would want to get the evidence that the state law allows.
So if in a normal court proceeding, let's say any personal injury case, for example, let's say we make a determination that I don't want to take the witness stand as a witness, right? I'm not preventing the court from receiving that information, right? The court would still be able to receive it. If the law says that we're entitled to get it, you would still be able to get it. I'm just making a strategic decision that I don't want to present that particular piece of evidence.
I think the difference...
How does that violate state law?
I think the difference here is you'd be making a local law that said that, whereas if the county attorney or the county executive wanted to direct employees in the course of a SCAR hearing what to do or not do, that's a different issue. But it's the lawmaking that makes a difference.
See, here's a philosophical question. The county executive doesn't get to do whatever she wants whenever she wants, right? The legislature has a role to play here, right? And so we have a role in setting some of these ground rules as well. We have the ability to tell the county executive, these are the ground rules that I want you to play under, right? That's lawmaking, right? That's kind of what we do.
To the extent that you're not prohibited from doing so by state law.
We're not prohibited.
Well, I think the county attorney has a different opinion, again, for the reasons stated.
But again, I'm trying to understand why the county attorney has that opinion.
Again, because it would be a law relating to taxes, which I believe is tantamount to assessment in this context. Plus, there would be an inconsistency with a general law, and the county is not allowed to make local laws inconsistent with state general laws.
I'm still trying to understand how it's inconsistent. I'm not changing what evidence the judicial hearing officer is able to receive. I'm controlling what evidence our own employees are able to offer.
I respectfully...
And by the way, making it more restrictive for the county.
I respectfully
right? as opposed to broadening it.
I respectfully disagree because, again, the ultimate penalty on the county through this law would be not being able to present evidence that otherwise would be presented in a hearing under the RPTL. So a judge who is looking at it as a case, again, a brand new proceeding, it's not a review of the assessor's work, getting evidence from the petitioner and getting evidence from the government, that judge is not going to get evidence from the government under certain circumstances in this law. Certainly not evidence that is normal and expected of three comparables, say, in a SCAR hearing, because this law says that the only evidence that can be presented is what the assessor did, which is a computer-assisted mass appraisal based on all the factors that you know very well, the ladder and all the rest. How the assessor builds a model assessment is much different from a review of that assessment asking for three comparables.
But that's actually not what the law says. What the law essentially says is that all we want the Department of Assessment to do is whatever we're going to rely upon at the SCAR hearing, we want disclosed to the petitioner in advance of the hearing. Now, we may have a discrepancy with respect to 30 days, and the hearing is only noticed 10 days before, so that's something that we can adjust and address. I'm trying to understand why it is that us simply saying, look, whatever information we're going to rely upon for the sake of fairness and transparency, we're going to disclose to the petitioner so they're not getting sandbagged at the hearing with something that they don't know about and haven't prepared for and can't prepare for and can't react to at the hearing.
But respectfully, it does more than that, and I'll read from the proposed law. The Department of Assessment shall only present evidence that it used to determine the assessed value in dispute and is precluded from offering any other evidence. So it does say that they can only present evidence that they used to determine the assessment, which is a different process from what goes on at SCAR.
So what would the county attorney's opinion be if we were to modify that language? Because I understand that there's some ambiguity there. If I were to modify that language, or we were to modify that language simply to say whatever evidence the Department of Assessment intends to present at the SCAR hearing must be disclosed to the petitioner within whatever time frame is reasonable.
I'm
You know,
reluctant
let's
to
say
discuss a
7 days.
hypothetical, and I don't want to give the county attorney's opinion, but I think that would be different than this.
Well, no, well,
evidence
really
that's
it's not, because if the basis for the county attorney's opinion is that somehow we're impacting state law by requiring this, that opinion should be the same, right?
Well, again, the various facets of the law that the county attorney has pointed out that are inconsistent, it deals with, again, that not allowing evidence that otherwise could be presented. So if you change the law to say any evidence that could be presented under the state law must be disclosed, I think that's a different question.
Well, out of curiosity, what would be the penalty? Because I think we all have experience on this board, and I know certainly Legislator Ferretti and I have experience with laws being passed and adopted by the county executive that she simply decided not to follow for a period of time.
I'm not going to address.
So
not going
my
to address
question
that
is,
point.
what exactly would be the sanction on the Department of Assessment for not complying with the requirement to disclose the information to the petitioner in advance of the hearing?
It's what I just read to you, that they're limited, to the proof of that. And finally, failure to timely disclose the proof precludes the department from offering evidence, any evidence at the hearing. That's your penalty that you've
No,
written.
I understand what the legislation says, but in the county attorney's opinion, what sanction is permissible?
I think I don't want to address a hypothetical like that.
All right, so the county attorney can only tell us what's wrong, he can't tell us what's right.
I think he can address legislation that's before him, and before this body, and that he's been asked to review. Again, a hypothetical is a different thing. You want to see it in writing. There could be nuances. You're an attorney. Hypotheticals are dangerous things.
I understand that, Mr. Denyon, but again, the larger point, and the thing I'm still having difficulty understanding, though, is why it is that setting the ground rules for our own employees impacts state law. So if we're saying, look, in the interest of fairness and equity, we're requiring that the Department of Assessment provide to the other side in an adversarial proceeding disclosure of our proof in advance of the hearing so that they can react and respond to it. And if you don't do that, we're making a decision as the county that we're not going to present proof at all at the SCAR hearing if we fail to do that. Why can't I as the client voluntarily do that? And how does that violate state law? We're not changing state law.
Under this,
we're just setting the ground rules that our own employees operate on.
Under this proposal, those ground rules result in the county not being able to present evidence that it would otherwise ordinarily do and that the court would expect to see, as in 3 comparable properties in the case of a SCAR hearing.
Well, the simple way to avoid that is doing what the law requires, right?
Which is?
Which is disclosing.
Well,
that's only a sanction if you fail to abide by the law.
No, what the law says is that you can't offer 3 comparable properties because it says you can only do what can only present evidence of what assessment did in setting the assessment, which is different. That's not 3 comparables. That's a computer model that generates an assessment.
Let's for the moment, let's look past that. Let's say there's an amendment here to the law, which again, the point of the law is simply whatever proof we're relying upon at the hearing, we've got to disclose it within X number of days prior to the hearing so that the claimant, the petitioner, has full disclosure.
I would reserve the right of the county attorney to review that when he sees it in writing, and I don't want to address it as a supposition or a hypothetical if the law were changed.
Would that satisfy his concern?
It may or may not, and I don't want to speak for him, but I don't have anything in writing. I don't want to speak to, again, a hypothetical. It's not the law we've been asked to review. We can only review the one that's before us.
But that seems to be the basis of the objection, right?
Again, there are a number of bases of objections here, and I'm not saying that things couldn't be improved or things could eventually be different. I don't know, but I can't speak for the county attorney, and we'd have to see what those changes were before offering an opinion.
Conceptually, it seems as though the county attorney would agree that we do have the ability to direct our own employees, right?
I think there's probably some room for that to the extent it doesn't interfere with the state general law or any other prohibition on the county's local lawmaking ability.
So I think we're in agreement that if we were to move this to if we were to move this to 7 days, that would alleviate the county attorney's concerns about the timing,
That one particular concern.
right? I think that if we were to modify the language, it sounds as though if we were to modify the language, that we must simply provide to make it clear that we don't have to provide the information we initially relied upon. We have to provide the information that we intend to use at the hearing in advance of the hearing.
I think you could take a look at that and see what it looks like.
That seems as though that would, conceptually, that would satisfy that concern.
Potentially.
So now, with respect specifically to the issue of preclusion from offering evidence, the county attorney's opinion is that the reason that we can't preclude the Department of Assessment from offering evidence if they fail to disclose it is because we're denying the state the opportunity to receive the evidence?
The hearing officer and the court, that's the standard practice, and that's the scheme, that's the framework of Article 7. It's an adversarial proceeding like any other, and evidence is presented on both sides. And out of that, again, it's a de novo proceeding to determine the assessment in question. It's not a review of the assessor's work. So if the county is not able to present evidence to the court in this brand-new proceeding, the court can't do what it's supposed to do under the statute.
Well, that simply would mean that the claimant would win, right?
And that leads to, again, the other issues about does that raise a question of waste? Does it raise a question of an improper gift when there is a defense to be made? Sure. It's I don't know how it would raise the question of it being an improper gift. But you know, essentially what we're talking about is that if the county fails to abide by our own internal procedures that we set up, we, as a penalty that we're imposing on ourselves, are going to say that we're not going to present evidence. Again, I think it rises to the level of interfering with the state framework, and that's
to our own disadvantage.
Maybe so, of course, but again, that's not what the law is. The law is whether or not we have the power to enact a local law that does that. And if the state has preempted the field, then you can't enact a local law that has the effect of changing the state's plan for Article 7.
So under no circumstances, according to Mr. Cashow, are we able to direct or control the evidence that we present in any judicial proceeding?
I think it's too broad a question. Again, the law before us, I think, fails in that test.
Well, but there are conceptual parallels to this. You know, again, for example, in any tax certiorari case, in any auto accident case involving a county vehicle, in any premises liability case, we don't have the ability to control what evidence we present?
You have to look at, if you passed a local law, to control that evidence to see whether or not it interfered with the application of a state general law. And if it did, then those questions would have to be addressed. It's not the question of administratively the county attorney deciding to do something. It's whether the county legislature has the power under the Constitution and under the municipal home rule law to enact a law that interferes with a state general law. Does it interfere with the operation of a state general law is the question you would have to ask in all those situations.
But how does, I guess the issue that I have is how does it interfere?
Because, again, it's a de novo proceeding where there's evidence presented on both sides. It's an adversarial proceeding that the county would be saying the county is not allowed by law to do that, even though the state law permits it. And any time a local law prohibits what the state law permits, it runs afoul of the laws against interfering with the state general law.
We're not changing. I guess my philosophical difference is that we're not changing the information that the state can receive. We're making an internal direction as a matter of policy and as a matter of law as to what evidence we're going to produce. There's a difference between what evidence is being produced and what evidence can be received, right?
Well, I think
the state can. We're not changing what information the state is able to receive. We're changing the information that we're actually going to present.
I do believe that the state is not going to receive any evidence from the county to counter the evidence presented by the petitioner. In general, petitioner will present evidence favorable.
So in other words, what I'm saying, would it be more clear if we said that if we don't comply with the disclosure requirement, we're simply not going to contest the petition?
Again, I think anything that interferes with the operation of the state is looking, the state has set up Article 7 as a way to determine the assessment. And the way it does that is it gets evidence from both sides and looks at the assessment brand new. And so if the county's passing a local law that interferes with that operation, how that's envisioned to work and play out, the court's looking to get evidence from both sides. And if it doesn't get evidence from both sides, why? Because a local law has changed the rules and changed the ground rules. I think that's what the problem is. It changed the rules
for only one side.
Which changes the rules for the state law. The state law
it didn't change the rules for both sides. It changed the rule for one side.
But for one side is interfering with how the law contemplates that the judge or the hearing officer arrives at the assessment by hearing new evidence from both sides. Not what the assessor did, but new evidence from both sides.
It's making a decision, a determination that under certain circumstances, we're not going to contest the petition. That's the equivalent of a preclusion from offering evidence.
Well,
it means that we're simply not going to contest, or we're going to argue based solely upon the information that's provided by the petitioner. Why can't we make a decision on behalf of the county? That's what we do. Why can't we make a decision on behalf of the county as to what we're going to produce, or whether we're going to produce evidence at all? Because under what you're saying, essentially, if the Department of Assessment made a decision that they weren't going to contest a particular petition that was before SCAR, we're not allowed to do that. So what's the difference between the Department of Assessment making that determination and the legislature, which controls the activities of the Department of Assessment, just as it does with every other department, making the determination that under certain circumstances we're not going to contest the petition?
I think the difference is local lawmaking and whether it's allowed.
So, well, let me ask this question then. Every year, it seems, the deadline for ARC is extended. We don't have the ability to actually extend the deadline ourselves, right?
I believe the way that's done is a grace period provided by the Assessment Review Commission.
Right. We don't have the state is the one that actually sets the deadline. What we simply say is we have made a determination that we're not going to enforce the deadline for a specific period of time. So if you're supposed to file your grievance by March 1st, we're going to give you until the 31st. It doesn't mean that that deadline isn't March 1st. It just means that we're not going to raise the defense of timeliness of your petition until we reach March 31st, right?
Are you asking about what the Assessment Review Commission is doing or what the legislative action was in those cases?
No, what I'm asking is, how is it that we're able to turn around and simply say, we're making an internal policy determination that we're not going to raise the defense of timeliness for an application that's made, whatever the dates happen to be. In this case, in my example, you're supposed to file it by March 1st. You filed it on March 30th. But you know what? We're not going to raise the defense of timeliness because we internally extended the deadline, or we simply said we weren't going to enforce the deadline up to March 31st. What's the difference between that and this?
When you say we, that's the question I was trying to ask. When you say we, if you mean the Assessment Review Commission has provided a grace period, that's, again,
well, I mean, every year the Assessment Review Commission is directed either by the county executive, or we have attempted to direct the Assessment Review Commission as a legislature, but the county has taken an action to direct the Assessment Review Commission that it's not going to raise the defense of timeliness for whatever the period of time is, whatever the grace period is. What's the difference between that and us legislatively saying to the Department of Assessment, hey, you know what? If we violate our own rules, we have decided that we're not going to raise a defense at SCAR.
Okay. The difference is that the Assessment Review Commission is acting administratively. It's not enacting a law. It's not passing a law that's conflicting with a state law. It's providing a grace period. And to the extent that the county attorney does not raise that as a defense, that's also an administrative decision. Those are not local lawmaking actions.
So what you're essentially saying is that if the county executive were to direct the Department of Assessment, if the county executive were to direct the Department of Assessment to do exactly what this law does, that would be permissible. But if the legislature passed it by local law, that would not be permissible.
Again, it's a hypothetical I don't want to answer. And
Well, I really need the answer to that question, Mr. Denyon, because it goes to the heart of what we're trying to do here. What you're telling me is, it sounds as though that the county executive has the ability to direct the Department of Assessment to do whatever it is that she wants to do, waive whatever laws she wants to waive, create whatever restrictions she wants to create, but the legislature doing it by operation of law as a co-equal branch of government does not have the ability to do that.
Not at all. It's not what I said at all. Again, it's not the county executive, in your other question, directing ARC. I believe the county executive requests, and ARC itself decides to provide a grace period. Whether the county executive could do exactly what's in this law, I think what's exactly in this law is problematic in a number of fronts, but again, that's a hypothetical. I'm not here to talk about what the county executive's powers are. It's a question of what this law purports
Mr.
to do.
Denyon, the question is simple, though. If the county executive were to make a decision today saying to the Department of Assessment, hey, look, you've got to provide whatever information you're going to rely upon at a hearing 7 days before the hearing to the petitioner so that they can have that information. If you don't, we're going to waive our defense at SCAR. Does the county executive, in the county attorney's opinion, have the ability to do that?
As we talked about earlier, that's an area that if the legislature did that, that said you have to, if the law was not interfering with state law, changing the evidence, but just saying that you have to present it to the other side within a certain amount of time, again, like to see that in writing, but that, as you and I talked, that could be an area where perhaps the legislature could legislate. So if the legislature could do that, I mean, again, without addressing the hypothetical too directly, that the county executive, is able, of course, to direct the departments that report to her in certain ways. But just telling what you're going to give to the other side, if it's allowed and permitted by state law, it's a different question. And again, that's something that could be looked at.
All right, do we actually have, I don't mean to sort of usurp your authority here. Do you want to continue with questions, if anybody else has questions from this witness, or I want to see if we have somebody here from finance?
I just had a couple of follow-ups.
I believe someone from OMB is available virtually, remotely.
Okay. Okay. We'll move on, transition to that in a moment. Is there anything in the law that prohibits the county from providing a pro se petitioner with a description of the type of evidence that they're going to need at a SCAR hearing?
I think that raises some troubling issues that the county attorney has identified. For a non-attorney at the Department of Assessment to do that, it would require knowledge of both the statute that governs the evidence and case law that has interpreted the statute, which could be seen as the improper practice of law, which carries consequences. And for an attorney to do it, it raises ethical issues of providing advice to both sides in a litigation.
So there's no way that the county attorney and Department of Assessment can sit down and write down a list of the type of evidence that a pro se petitioner can bring to court because it violates ethical obligations on both?
It's legal advice. It's governed by statute and case law. Where do you start and where do you stop?
To be honest with you, our approach here is we have identified what is an unlevel playing field at these SCAR hearings. And we've identified that by talking to the people, individuals, residents who go to these hearings. And it seems to me that the administration likes the unlevel playing field, and they like it because of financial reasons. I mean, you set forth that one of the main reasons to oppose this is because the county would lose revenue. And every suggestion we've given you, you've given us a reason why you can't do it. And that in particular seems flimsy. I don't, for a moment, believe that this government couldn't put together a fact sheet and provide it to a resident who's going to a SCAR hearing, and that would not be a violation of an attorney's duties. It would not be illegal practicing of law. I believe that's done all the time. I mean, if you go agencies across the state, if you have challenges to those agencies, will tell you what you had to present at a hearing. So, I mean, the fact that you're resisting that is kind of stunning to me.
I can't speak to the other statutes, but I will comment that the whole point of the SCAR statute is to be as informal and friendly as possible, and representatives do not have to be attorneys, so representatives are eager to represent everyone who's out there who wants to do it pro se, who wants to, challenge their taxes. I think they're out there trying to represent people. Attorneys are obviously trying to get that business. I don't know if it's the county's business to represent or try to make legal representations to someone on the other side of a litigation.
It's not a legal representation. They're simply providing a general description of the type of evidence that an individual could present, and it's not a friendly proceeding. The representative from the county is trying to defeat the claim of the petitioner. So it's not a friendly, they're not being, it's not a helpful procedure. And all we're trying to do is give someone who's challenged their assessment, who goes to this length to a SCAR hearing, give them the simple tool to determine what I can come in with and what I can present to this court, to the judicial hearing officer. Does the county have the power to determine what evidence it's going to present at the SCAR proceeding?
I believe that the administration does, but again, back to the question of whether the county legislature can enact a local law that changes the evidence that the court.
So when this proceeding is taking place, it's the county that's defending, correct? You're making a distinction in response to a very simple question. When the county of Nassau is participating in these proceedings, it has the ability to determine what evidence it's going to rely on, correct?
Well, the departments that are involved are the Department of Assessment and the County Attorney's Office, and there is discretion to determine the scope, right, and the breadth of the defense, sure.
Do those departments have the power to determine whether in advance they're going to provide these pro se petitioners the comparable sales that they're going to rely upon?
I don't believe that they have that authority. I think it raises ethical and the other issues that we've discussed. I don't know if we could just, on their own, present.
You're an attorney, correct?
Sure.
Your office handles discovery, civil discovery, every day, correct?
Sure.
And your office is providing to plaintiffs every day information about the county's case. As much information as possible, correct?
Again, I think we agreed on that point that what the county's evidence is something that probably, could get done under a different version of this, but.
Right. So, I mean, it's different from what you just said, but
no, I'm sorry.
I think we can agree then that the county can decide that it's going to disclose its comparable sales if it wants to.
Again, just to be clear, what I'm being consistent on is that the county could disclose its evidence, but it's a different thing to say that it's going to provide advice what the other side can present. That's a different thing to me.
We had that discussion, and I think that position is unsupported. Again, there is nothing that would ever prevent this county from putting together a fact sheet and sending it to a pro se petitioner before the event and saying, here's the type of evidence you need at this hearing, just in a general way. There was no way that violates anybody's ethical, legal, professional responsibilities. And again, the resistance of the county to this leads me back to, I think that this is why we're going to need someone from finance, that it almost seems as if the county enjoys the level playing field and enjoys the fact that it can defeat Joe, who comes in, trying to get his assessment corrected because Joe doesn't know what he's doing. The county has all the power. So it seems that that's what the real resistance is, not what, not what you're suggesting.
I respectfully disagree. Again, that the county spends a lot of money and time at ARC to make sure that those pro se petitioners have the ability on the administrative level at no cost to file at no cost at ARC to get a resolution at that level. As you know, you've been here forever. It's been a big process with ARC to improve ARC over the years, but a year's worth of time to do that. Increased staff, increased budget. They're doing their best for pro ses. I believe maybe Mr. Miles could address the outreach to pro ses at ARC, but I think the county is trying to help pro se petitioners get a resolution as expeditiously and as inexpensively as possible. But when it gets into a court proceeding, then these issues do unfortunately come up.
Okay. Is there anyone here from finance?
I believe it may be remote.
Okay.
I believe he's on. Phil?
Yeah, I'm here.
Phil Wasserman from OMB is on remotely.
All right. I guess Mr. Orlando was not available. We had the memo we have, actually, the memo we have is from him.
The request for Katie Horst from the administration, the request for DC Orlando came in as this meeting was starting, so he was not available, but Phil did make himself available.
All right, thank you. All right, Mr. Wasserman, you familiar with the memo that was submitted by DCE Orlando?
Yes, I am.
Okay, and can you want to just summarize what that memo says?
So what we looked at was basically what would be the implications for the county financially if we were to lose 100% of the pro se cases, 80 and 60% of the pro se cases. And this was an estimate based on the previous year. And we just sort of scaled up the cost to the county, assuming those losses.
Legislator Ferreira, you finished?
I'm sorry,
Mr. still going on?
I'm sorry, I couldn't catch that.
I'm sorry, I thought you had stopped and then you started talking again, so I wasn't sure if you were done or not.
Yeah, then we also looked at what would happen if this law was extended to all SCAR hearings. And there that we showed what would happen on a hearings basis and then for all filers, assuming all SCAR filers would basically push for a hearing with this law in place.
Legislator Ferretti.
Thank you, Presiding Officer. So I have questions kind of for probably all three of you, Mr. Wasserman, Mr. Miles, and Mr. Denyon. So, Mr. Denyon, if I could start with you. I might kind of like go from one to the other. It's just easier. But, Mr. Denyon, the county attorney opinion, who requested it?
I believe I could have been OLBR. Did Maurice, I believe. OLBR.
Well, that's who it was provided to, right?
Yes, it was given to.
But who actually requested it? Was it the administration or the county executive's office? Who requested it?
I believe the administration, so I don't know if Maurice wants to address that.
Maurice Chalmers, OLBR. We reached out to the administration to ask them for an impact, projected impact on this local law, and we got those two memos back.
From who?
From the county executive's office, administration.
Okay, so the county executive requested this county attorney opinion. Is that correct?
That would be correct.
Okay. So, Mr. Denyon, I see there are 3 questions presented. Now, the presiding officer, Legislator Rhodes, they've kind of dug into question 1 and 2. But I'm just looking at question 3, and maybe this is a question for Robert. I'm trying to understand why a question from the county executive office as to the financial impact would go to the county attorney's office to begin with.
I think it's to address the legal aspects of, do we think that this would have an effect In general, we don't speak to the numbers, of course, because that's an analysis that OMB has done. But as you've read, we think that more cases would be lost, and therefore more refunds would be had, and then additional potential claims of waste or gift issues, which could lead to other damages. If this had a disparate impact, is another potential claim that's raised in the memo. So I think there were legal aspects of would this tend to have an impact on the county finances that were proper for this memo to address.
Well, let's just talk about your opinion as to number 3, the negative impact on county finances. Now, just reading a section in the middle of the first paragraph. Additionally, represented petitioners would almost surely demand that the county amend the local law to expand its provisions to them in the interest of equal treatment under law and fairness to all taxpayers. What basis do you make that assertion?
I believe that it's seen as if pro se petitioners had this ability to go to court without any evidence on the other side, that perhaps the represented taxpayers would say, well, we'd like to have the same benefits of the law, that if the county doesn't do what it's supposed to do, it could result in this very favorable treatment to them as well. And if so, that would lead to greater refunds.
So number 3 here, your opinion is based on a hypothetical.
I think it's based on a natural result that would come from this law being passed.
So that's a natural result.
I think it's an extrapolation of what's going on here, of what would happen.
And are you also extrapolating that this body will vote a certain way to appease those non-pro se filers?
I don't believe the memo says anything like that.
But your opinion is taking a position based on a hypothetical. Just about a half an hour ago, you told Legislator Rhodes that hypotheticals are dangerous. This entire opinion is based on one.
I wouldn't consider this a hypothetical. If something happened, that happened. I think this is again
an
extrapolation of a likely result of the law.
I'm sorry?
I think this is an extrapolation of what would happen as a result of this. If this
hypothetically. Yes?
I don't know if I'd use the same word.
What word would you use?
Extrapolation.
Okay. How many, and this may be for Mr. Miles, how many SCAR petitions were there this last year?
80,000.
And how many were pro se?
Approximately 550.
And what was that about? Is that about 5%?
I'm sorry?
Is that about 5% of the filers were pro se?
Potentially,
I'm sorry?
Potentially, I didn't do the math on the...
Okay. So really what we're talking about here is about 5% of the filers that are actually pro se.
Potentially.
Okay. And so from that, Mr. Denyon, you're extrapolating that 100% will all of a sudden turn and demand that they have this disclosure as well.
I get it. The memo says that they would likely demand this, so I didn't think it says 100%, but it's a likely result of this law being enacted.
Okay. And let's assume for a second that your extrapolation, my hypothetical as I read it, is correct, and 100% demanded. Let's also assume that this body was to vote for that. Why is it assumed that the county would lose every single case?
It's the risk, I think, that this is talking about, that the risk that if, as the law is written, with a 10-day notice from the court, a 30-day notice required by the law, all those cases would be lost because we could not comply, then those would be just a series of lost cases.
So the quote-unquote most accurate assessment ever, we would lose all the cases?
At the judicial review stage, it's not an issue of whether or not what the assessor did. So it's a brand new look at it, right? So if there's only evidence on one side what the assessment is, that's all the court has before it.
All right. Well, I think we've talked ad nauseum about the first and second questions presented to the county attorney's office, and it sounds like that the bill can be tweaked to appease the concerns at least listed in here, although I'm certain there'll be more once those concerns are fixed. But if they were, we still have this number 3, this issue of the financial impact. Now, if those concerns in question presented 1 and question presented 2 were appeased, then the county should be able to give the same exact evidence that they, always could have. It's just they have to disclose that evidence to the other side. Just like every other court proceeding that I could think of, you have to exchange evidence, right? So if number 1 and 2 could be rectified in the county attorney's mind, would that change the financial impact? Now, I'm not hypothetical, that's just extrapolating.
I agree with you. If you change 1 and 2, it's going to change 3.
Okay.
To some extent, yeah, whatever that might be.
Mr. Wasserman.
Yes, sir.
Okay. So, just reading through the memo here, I want to understand what the administration's position is on SCAR hearings. What's the point of them?
I don't know if that's a question for...
No, Mr. Wasserman.
Well, I mean, I would assume, you know, you send out a tax bill and that you believe is the best representation of what the taxpayer owes, and you have a responsibility to the other taxpayers to defend that.
Right. So what we're looking for are fair and accurate assessments, right?
I would believe so, yes.
So, as a threshold question, is the point of a SCAR hearing to win at all costs or to get the assessments right?
I'm sorry. I'm a budget person, but I think you should be asking the people who try these hearings.
Mr. Wasserman, the reason I'm asking you is because you're speaking on behalf of Mr. Orlando, correct?
Yes, that's correct.
All right. And I'm referring to Mr. Orlando's memo, where he indicates that as written, the legislation could result in the county losing almost all pro se cases with a resulting liability of $800,000. Now, I would hope that that's not the case, considering we just had a reassessment and supposedly it's the most accurate in the history of the world. But just assuming that that's true for a second, my question is, and I hate to be frank, but so what? If these people were not assessed properly, and these residents go to SCAR, and the evidence that we used is disclosed to them, and we nevertheless lose, God bless. You weren't assessed properly, you went through the system, and you won. What's the problem with that?
I think in a fair trial, if the taxpayer proves that the assessment was incorrect, then mazel tov.
Well, I agree. Okay, good. We all agree. But then why does this memo seem to indicate that that's a major concern? When in fact, this memo only addresses that.
I believe, our understanding that the impact of this law will impact the ability of the county to properly defend the rule, properly defend the assessments that was made.
Okay. Well, look, I think it's pretty clear that, 3 questions were presented for this opinion, but really, it sounds to me like all they really care about is number 3, the financial impact. And what we should be shooting for is that residents in Nassau County are taxed and assessed fairly and accurate. And what we're trying to do is to make a level playing field here. And it sounds like the administration is doing everything it can to keep an advantage. That shouldn't be the goal. The goal should be fair and accurate assessments. That should have been the goal throughout this entire process. And it seems like every step of the way, when we try to make that the goal, we get some other, I'm going to say it, Rich, gobbledygook thrown at us to tell us why we can't do it. Thank you.
Are there any other questions? Yeah, sorry. Legislator Walker.
I really didn't have a question, and I guess I really am just summing up again what Legislator Freddie just said. But yes, I'm a legislator, but I'm also a taxpayer. I'm a widow. I struggle every day to make ends meet, and if I'm fighting my assessment, I want to go there and I want to be able to have everything presented that I can present, but know what I'm up against, know what I'm fighting against, like you would in court, know what you're up against. And from everything that you've stated, it just reinforced over and over and over to me as a taxpayer and as a legislator that we don't really care if the assessment is right. When you get to that point, we just want to win and take their money. And that's what it points out to me, and I think any resident that might be sitting here is going to feel that same way. And they're not on a level playing field. And yes, the county might lose money, but then it's because their home was assessed improperly. And many of our homes are still assessed improperly. And I think we know that, and we can say this is the best assessment ever, and it's fair, and it's wonderful, but many of our homes are still assessed improperly. And that's a problem. And it's a problem now that all we care about really is worrying about losing all those, or whatever it is. I'm so confused at this point.
The SCAR.
But the SCAR petitions, you're concerned about, well, we could lose basically all of them. Well, too bad if we do, because then the houses weren't assessed properly. And those people there who aren't represented by an attorney, they're doing it on themselves. They barely understand the whole assessment process to begin with. And now it's just another way to say, gotcha, you lose, we win. And that's my perspective of what's all been said this afternoon.
Would I have a chance to respond?
Sure.
So I would say that, the county is just trying to have obviously fair and accurate assessments at the Department of Assessment level. It's done, it's done a great job over the last 2 years with the reassessment. ARC is doing its best, and also when it comes to the court procedure, when it comes to judicial review, county attorney, Department of Assessment are doing their best to be fair to both the petitioner and to the taxpayers who have to pay the refunds. And so it has to be a process that is the one that's was respected. Is based on the current state law procedures that ensure fairness, and that the truth does come out of the proceeding, so that it does result in a fair and accurate assessment. But I think the core of the problem here is this changes that state operation of law to arrive at that truth by changing the inputs, changing the evidence, and therefore it presents an unfair advantage. The county shouldn't have an unfair advantage, and the petitioner should not have an unfair advantage. The state law properly balances that. This tips the balance a little too much in another direction, which harms all the county taxpayers who have to pay those refunds.
Legislator Drucker.
Thank you, Presiding Officer. I think this entire body recognizes that we all want the same thing. We want a fair and accurate assessment. But once the SCAR matters get to a hearing, it becomes an adversarial proceeding. It becomes a trial. It becomes it's called a trial de novo. Start with the person responsible for obtaining the truth and accuracy is the hearing officer, the judge. So, I think we all want the same thing, but once it gets to that point, we're talking about a judicial proceeding. It's not policy. It's not process any longer. It's a matter of which side is going to prevail. And both sides try to present what they have in the most favorable light. But I think that to summarize here, Legislator Rhodes and the presiding officer, after a very brief period of time, after an hour and a half of this, though, their line of questioning shifted to hypotheticals. It was always if. If we did this, if we did that, if we did this, and if we did that, why can't we do it? Well, those are fair questions, but they're not fair questions today. Because isn't it true, Mr. Degnan, that this bill before us is trying to do indirectly what we can't do directly, which is to change the SCAR process. And that's why it conflicts with state law. Isn't that correct?
I agree, yes.
So, we've spent a lot of time discussing hypotheticals, and I understand we should know what our parameters are as legislators. But it's not before us today. This bill is fatally defective on its face, and it can't go forward. And I think the majority recognizes that, because their line of questioning shifted early on to if we do this and if we do that. Would you agree with that?
I'd rather you characterize the nature of the questions.
Okay. I just wanted to make that point. But you agree, though, that what this bill does on its face is patently defective because of what it's trying to do indirectly, what we can't do directly.
For the reasons discussed, yes.
I have no further questions. Thank you.
Okay, thank you. Legislator Rhodes.
Just in response to that, look, the whole idea behind a hearing is to give voice to concerns on both sides of legislation. There's absolutely nothing wrong with asking, okay, let's assume that a point is being made. Well, what happens if we address it in this way? I mean, talking about hypotheticals or talking about extrapolations or whatever the terminology is that you want to use. So I don't know how one is somehow good and the other one isn't. That's part of the lawmaking process. So I don't have a problem with asking those questions, getting feedback, and trying to find areas where there's common ground that we might be able to reach a resolution. My whole question in this process is there common ground to reach a resolution? Because I think what we're seeing here is that we have a county executive who does not want to do this and is using the county attorney's office to come up with reasons for why it cannot be done, simply because she does not want to come out and say we don't want to level the playing field when it comes to SCAR. That's my concern. Whether that bears out remains to be seen. If there are amendments made to this legislation and it passes, it remains to be seen what the county executive winds up doing with that. But, ultimately this legislation is about leveling the playing field. And it is about fairness. And it's about disclosing, as you would do in any other court proceeding, disclosing the evidence that's going to be presented to the other side so that both sides aren't surprised at the time of trial. That's not anything earth-shattering. That's something that's done in virtually every other area of the law, except for some reason at SCAR. And our legislation has no broader implication statewide than Nassau County. And we do have the ability to control what happens in Nassau County and how we respond and how we react to that. We still have the ability to control what our own employees do, even with respect to what they present at the SCAR hearing. So, I appreciate, I appreciate your testimony here today, Mr. Wassman, Mr. Miles, and Mr. Denyon. I think it's given us some food for thought, and I know we'll be revisiting this very shortly.
Yeah, I want to echo what Legislator Rhodes said. I want to thank you for your comments, and again, that gives us some food for thought going forward. I would like to invite Mr. Cashow down for a hearing on Friday afternoon if he's available. Just kidding. I know that's his last day. I think there'd be a revolution if I did that. So, okay. So thank you. We'll
thank you.
Close the hearing. Motion to close. Legislator Rhodes makes a motion to close. Legislator Ferretti makes a second. All in favor of closing the hearing signify by saying aye. Those opposed?
Aye.
Hearing is closed. We will not be calling the proposed local law today, so we have one other hearing. It's a hearing on a local law to amend the Nassau County Administrative Code with respect to vendor integrity and disclosure documents for municipal corporations and districts as defined by Section 119-N of the New York State General Municipal Law. Legislator Walker moves that, seconded by Legislator Drucker. That's a motion to open the hearing. All in favor of opening the hearing signify by saying aye. Aye. Those opposed? The hearing is now open. Let's see. This is legislation intended to facilitate one aspect of the CRP process that the county undertakes. And these revisions that we're going to be making in a few moments when we get to the vote on the law was a collaborative effort between the majority and minority caucuses, and I thank both counsel who worked on this. But this legislation is intended to end the requirement with respect to municipalities who submit IMAs with the county for various grants to prevent those municipalities from having to come back every 6 months to file new disclosure statements when nothing has changed. So the legislation will require that a municipal corporation or district will have to submit updated vendor integrity and disclosure documents when a principal, as defined by the charter, is newly elected or appointed. I believe there's, yes, and it also requires municipal corporations or districts to provide vendor integrity and disclosure documents every 5 years. Again, it's trying to avoid having the repetitive requests from municipalities to submit these documents when nothing has changed in the course of 6 months. Any debate or discussion? Nope. All right. Motion to close the hearing by legislator. Oh, sorry. I didn't think you was commenting.
I just want to say this was a bipartisan effort, and I appreciate both sides of our caucuses here. It was good to work together with our legal teams as well as all the legislators, and I really think that this will hopefully help make this process a little bit smoother for each one of us. So it was good to do together.
Thank you. And there's another item coming later on that was worked on by both sides as well. So motion to close the hearing by Legislator Bino, seconded by Legislator McKevitt. All in favor of closing the hearing signify by saying aye. Aye. Those opposed? Carries unanimously. We move on to item 12, which is a vote on a local law to amend the Nassau County Administrative Code with respect to vendor integrity and disclosure documents for municipal corporations and districts as defined by Section 119N of the New York State General Municipal Law. Moved by Legislator DeRidge Whitten, seconded by Legislator Ford. That's before us, and we need to make an amendment in the nature of substitution. And as stated before, the amendment clarifies that a municipal corporation or district must submit updated vendor integrity and disclosure documents when a principal, as defined by the charter, is newly elected or appointed, and further requires the municipal corporation or district to provide vendor integrity and disclosure documents every 5 years. Motion to amend by Legislator Ford, seconded by Legislator DeRidge Whitten. All in favor of the amendment signify by saying aye. Those opposed? The amendment passes. On the amended item, any debate or discussion? All in favor of the amended item signify by saying aye. Aye. Those opposed?
Aye.
Carries unanimously. Move on to item 14. It's an ordinance number 46. It's an ordinance to amend ordinance number 105 of 1985 as amended by ordinances 154 of 1989, 103 of 2000, and 203 of 2001 with regard to maintenance and guarantees associated with road openings in Nassau County. Moved by Legislator Rhodes, seconded by Deputy Presiding Officer Copel. Legislator Rhodes, do you want to make comments?
Sure. The bill itself is rather simple. Nassau County spends in 2020, 2021, will spend approximately almost $80 million for road resurfacing projects. All throughout the county, and one only needs to travel on Franklin Avenue right outside of these chambers. You saw a perfectly good roadway that was opened up by a utility who then placed a temporary patch, and as a result, anybody that's traveling right now northbound on Franklin Avenue, one would think that you're driving, hopefully you're driving an all-terrain vehicle in order to get over the roadway. What this legislation seeks to do is to hold utilities accountable for the patchwork that they create. Does a couple of things. If a utility opens up a roadway, it has 60 days to replace its temporary patch with permanent restoration, unless there are some sort of exigent circumstances which are brought to the attention of the Department of Public Works that they would have to agree that those exigent circumstances exist. If the utility does not make the repairs within 60 days, the permanent in-kind restoration, so in other words, if it's asphalt, they have to replace it with asphalt. If it's concrete, they have to replace it with concrete, because we've seen that as well. Concrete roadways where they put in a permanent patch if that's asphalt. Not good enough. You got to put what was there. If you broke it, you got to replace it. if they don't make the repairs within 60 days, it gives the Department of Public Works the ability to come in and actually make the restoration ourselves to our specification and then bill back the utility for the cost of those repairs. It also enables the county to charge the utility a per diem fine for the length of time that it takes to make that restoration. So it seeks to hold the utility accountable and responsible as well for the patches that they actually do put in. They are responsible to maintain those patches for the useful life of the roadway as determined by the DPW commissioner. Again, it's an issue of fairness for the utility and an issue of fairness for taxpayers. The useful life of the roadway is determined by the commissioner, because if a roadway that's going to be replaced in 18 months is what's disturbed, obviously the utility shouldn't have a 10-year period that they're responsible for it when we're replacing the roadway. Conversely, if it's a brand new road and they're opening up the roadway, they should be responsible for maintaining it for however long it is that we expect that roadway to exist. Again, this is about protecting the investment that county taxpayers are making in county roads that are disturbed by public utilities, and at the same time making sure that those roadways are passable as quickly as possible once that work has to take place.
Okay. Thank you. Any other legislators want to comment? Legislator Drucker.
Thank you, Presiding Officer. I have no problem with this bill, per se. I really think it's a good bill. However, I have a question for Legislator Rhodes or anybody else on the majority. For full disclosure, did you discuss this bill with the public utility companies? And, is 60 days enough time to conduct the necessary permanent rehabilitation or, to the road? I just want to make sure.
Sorry, I did have some conversations, not related to this bill, but I did have some conversations with New York American Water with respect to roadway restorations. I have had conversations with respect to National Grid regarding some clarifications that they wanted with respect to the bill. That was the timeliness of it was not a concern that was raised. So the 60 days, I didn't ask that question specifically, but the 60 days doesn't seem to be a source of any concern.
They raised it with me, so I just wanted to know if you had any further discussions on it. They did raise that the 60 days could be potentially problematic, but you know what? It is what it is. So.
If there are exigent, and that's why if there are exigent circumstances, they can certainly explain that to the Department of Public Works, and it gives the Department of Public Works the flexibility to be able to adjust that time frame based on circumstances on the ground.
Anyone else? Okay, hearing none. All in favor of this item signify by saying aye.
Tomorrow, and the person is leaving on Wednesday. I will not have enough time to meet them. Sorry.
No problem. All in favor signify by saying aye. Those opposed? Carries unanimously. Item 21, resolution number 76, a resolution authorizing the county executive to execute an agreement with American Traffic Solutions, Inc., DBA Vera Mobility, and 2 agreements with school districts in relation to the county's bus stop armed photo enforcement program. Let's see, moved by Legislator Walker, seconded by Legislator Millet.
Oh, I'm sorry. Allison Malamy, Deputy Commissioner, Shared Services.
Thank you for coming today. The IG has informed us that she is still undertaking an investigation into the contract which he has not completed yet. So I don't believe the legislature will be passing this today. We have meetings coming up, both committees and full legislature in June. We could always defer action until that time. But I had one question. I'm sure other legislators have questions. The warning time period in the agreement with the vendor is 30 days, correct?
Yes, well, that's the amount of time that's stated in the local law is 30 days.
So my understanding is that Suffolk extended theirs to 60 days.
I know their warning
I
period.
think Katie would like to say something.
We're going to be introducing legislation to extend that warning period to 60 days.
Okay. So the local law that you were referring to is the local law that's before us, or a law passed by the state of New York?
The law passed by the legislature here.
Katie, you want to clarify? Or somebody?
Dan Gregoire, Deputy County Attorney's Office. Yes, that's correct. Allison had stated that correctly. It's the local law that the county legislature had approved. They had a 30-day warning period in that local law legislation.
All right, so that has to be changed by local law to 60 days, correct?
Correct, and I guess, as Katie just confirmed, the administration is going to be proposing, a new local law or amendment to that local law, extending it to 60 days. And I think the agreement itself is pretty flexible with respect to the warning period, so I don't think we'll have it doesn't specifically state a 30-day warning period,
right.
So I think we should be okay on that front. It's just a matter of amending that local law.
Okay, all right, thank you. Anyone else? No, I guess, thank you. As I said, the IG is completing her investigation and report, so we're hopeful that we can take action on this in the very near future. But for today, we are bound to wait until she finishes. Okay, thank you.
Thank you.
Last item is Resolution 83. It's item 28. It's a resolution authorizing and directing the Nassau County Department of Information Technology to provide legislative staff read-only access to the county's electronic contract routing system, ECRS. Moved by Legislator DeRidge Whitten, seconded by Legislator Ford. Again, this was a collaborative effort between the majority and the minority. The item is going to be amended, and the amendment will do the following. It will specify that the information that must be provided by access to ECRS, including but not limited to the status of departmental improvements of agreements pertaining to CRPs, departments that approved such agreements, the date approval was given, as well as the department for which approvals are pending. Legislator Ford makes that amendment, a motion on that amendment. Legislator DeRidge Whitten seconds that. Any debate or discussion on the amendment? Nope. All in favor of the amendment signify by saying aye. Those
Aye.
opposed? Okay, passes. The amendment passes unanimously. Again, this relates to the county's CRP grants. We'll give the legislature the opportunity to look at the ECRS system without making changes to identify where a particular grant is in the process. If it is still pending approval for some length of time with a specific office, we can make inquiries of what the delay is, but the motivation is to try to streamline the process and get these through the system more quickly. As to the item as amended, all in favor signify by saying aye. Those opposed?
Aye.
Carries unanimously. Motion to adjourn, Legislator Rhodes, seconded by Legislator Muley. All in favor of adjourning signify by saying aye. Those opposed?
Aye.
Carries unanimously. We are adjourned.
Mm.